Rikers Island, the boy who spent 1,000 days without trial. This is not a story about a hardened criminal. This is a story about how the American legal system took a teenager, a kid from the Bronx who had never been convicted of a felony, and locked him inside one of the most violent jail complexes in the world. And then it kept him there for 2 years, 11 months, and 28 days, without a verdict. What you're about to see isn't a worst-case scenario. It's a documented pattern, one that New York City's own investigators confirmed, one that federal courts addressed, and one that ultimately destroyed a young man who refused to do the one thing the system demanded of him: admit to something he said he didn't do. By the time Kalief Browder finally walked out of Rikers Island, something had broken inside him that doctors couldn't repair. His family could see it. He could feel it. And this is the part the news cycle mostly skipped. The system that broke him is still running today. Stay with me, because the evidence tells a story the headlines never finished. Rikers Island sits in the East River between Queens and the Bronx. You can see the Empire State Building from a yard. On a clear day, you can see LaGuardia Airport, planes rising into the sky every 2 minutes. Everywhere you look, there's a reminder of a world you cannot reach. There's only one way on and one way off. The Francis R. Buono Memorial Bridge, a single two-lane span that officers, family members, inmates, and lawyers all share. That geographic isolation is not an accident. According to urban planning historians and criminal justice researchers, Rikers was deliberately positioned to create distance. Distance from attorneys, distance from courts, distance from the press. The problems at Rikers are not new. They're not a product of one bad warden or one bad era. The U.S. Department of Justice launched a formal investigation into Rikers in 2013. What federal investigators found that year describes a facility where adolescents, kids between 16 and 18, experienced what the DOJ report called a culture of violence. According to that federal report, young inmates at the Robert N. Davern Center, the adolescent unit where Kalief Browder was held, faced guard-on inmate violence at a rate that investigators described as unconstitutional. In one documented period, there was on average one use-of-force incident per day involving staff and adolescent inmates. But before we get to the specific violence Kalief Browder faced, before we get to the footage, you need to understand what Rikers actually is. Because most people think of it as a prison. It isn't. Prisons house people who have been convicted and sentenced. Jails hold people who are waiting for arraignment, waiting for trial, waiting because they cannot afford bail. According to the Vera Institute of Justice, on any given day in New York City's jail system, approximately 88% of people held pretrial could not afford to pay their bail. They were legally presumed innocent. They were functionally imprisoned. For Kalief Browder, that wait lasted 1,111 days. Rikers Island was not always an island. In the 19th century, it was a small plot of 87 acres, a farm owned by the Riker family. The city of New York acquired it in 1884. What you see today is the result of decades of expansion built almost entirely on landfill, much of it garbage and ash from the city itself. The main jail complex opened in 1935. At various points in its history, it has held up to 22,000 people simultaneously. For nearly 90 years, city officials, investigators, and reformers have declared Rikers a crisis. And for nearly 90 years, it has remained open. According to a 2019 report from the New York City Board of Correction, the facility's problems, violence, inadequate medical care, excessive solitary confinement, were not aberrations. They were structural, built into the institution at a foundational level. That is the system Kalief Browder entered on a May night in 2010. He was 16 years old. The Robert N. Davern Center, RNDC, is the section of Rikers specifically designated for adolescent males. In 2010, New York State still prosecuted 16 and 17-year-olds as adults. That law wouldn't change until 2017. What that meant in practice: teenagers who had never been convicted of anything sat inside the same system as adults with lengthy criminal histories. They were classified separately, but the culture, the violence, and the rules were the same. According to the DOJ's 2014 investigation, the RNDC had a documented problem with guard-initiated violence, what investigators called beatings, that staff frequently categorized in paperwork as use of force incidents, obscuring the nature of what happened. Former inmates consistently report in testimony and interviews that arriving at Rikers as a teenager felt less like entering a legal holding facility and more like entering a war zone. One where the rules of engagement were unknown and where your physical survival depended on decisions made in the first 48 hours. That is where Kalief Browder's story begins. May 14, 2010. The Bronx, New York. Kalief Browder, 16, is walking home with friends after a party. It is about midnight. According to police reports, a man named Roberto Bautista stops the group. Bautista claims that Browder and his friends robbed him 2 weeks earlier, that they stole his backpack. Browder denies it. His friends deny it. But Bautista's accusation is enough. Police arrest Browder on the spot. Here is where the system's machinery begins to grind. Browder had a prior record, not violent offenses, but an unrelated juvenile incident. That record escalated his bail. A judge set it at $3,000. $3,000. The price of a used car. The price of Kalief Browder's freedom. According to his mother, Vanita Browder, the family exhausted every option. They tried to borrow the money. They couldn't put the full amount together in time. The mechanics of cash bail, a system designed, its critics argue, to hold poor defendants regardless of the evidence against them, held Kalief Browder in a cell. He did not go to Rikers because a judge found him dangerous. He did not go to Rikers because prosecutors had overwhelming evidence. He went to Rikers because his family was poor. Here is the first rule of surviving the American pretrial detention system that most people on the outside never see. The fastest way out is to say you did it. Plea deals are the architecture of the modern American justice system. Prosecutors offer reduced sentences in exchange for guilty pleas. Defense attorneys, facing overwhelming caseloads, often encourage clients to accept. Judges ratify the agreements. The problem: that system rewards confession regardless of guilt. According to reporting by Jennifer Gonnerman in The New Yorker, the journalist whose investigation in October 2014 first brought Browder's case to national attention, prosecutors in Browder's case offered him a plea deal that would have given him time served and allowed him to walk out of Rikers. All he had to do was say he was guilty. He refused. That decision, principled or stubborn depending on your perspective, is the hinge point of this story. Because the alternative to accepting a plea deal was waiting for a trial. And in the Bronx court system in 2010, that wait could last years. According to court records, Browder's case was adjourned, delayed, at least 31 times over nearly 3 years. Court delays in the Bronx were not unusual. The Bronx had the most backlogged criminal courts in New York State, with public defenders carrying caseloads far beyond the recommended limits set by legal bar associations. Each delay kept Kalief Browder on Rikers Island. Each delay reset the waiting. Each delay sent him back to his cell. The second unwritten rule at Rikers, especially in the adolescent unit, is this: violence is a currency. According to the 2014 DOJ investigation, investigators reviewed 6,000 use-of-force reports from the adolescent unit over a 2-year period. What they found was that guards used physical force against adolescent inmates at a rate federal investigators deemed unconstitutional, and that staff frequently escalated conflicts rather than de-escalating them. Former Rikers inmates who were housed at RNDC during the same period Browder was held, some of whom spoke to journalists and gave testimony in civil litigation, described a consistent pattern. Guards singled out inmates who pushed back, who filed complaints, or who refused to comply with orders they believed were arbitrary or abusive. Pushback was punished, and the most common form of punishment was solitary confinement. Solitary confinement at Rikers, officially called punitive segregation, means 23 hours a day alone in a cell approximately the size of a parking space. 1 hour outside, often no contact with family, limited access to books, limited access to legal counsel, limited access to anything. According to the United Nations standard minimum rules for the treatment of prisoners, known as the Mandela Rules, solitary confinement beyond 15 consecutive days constitutes cruel, inhuman, or degrading treatment. Kalief Browder spent approximately 2 years in solitary confinement, roughly 700 days, in a cell the size of a parking space, before he had been convicted of anything. The third rule of pretrial detention at Rikers Island is perhaps the most insidious. Time works against you. Every day that passes on Rikers Island while you wait for trial is a day that erodes you, psychologically, socially, physically. Your family moves on. Your friends lose contact. You fall behind in school. Employers won't wait. Relationships fracture. And for adolescents, every day inside a violent institution during the years when the brain is still developing is, according to neurological research, a day that rewires how the brain processes threat, trust, and safety. According to court filings and family testimony, Browder's mental health deteriorated across his 3 years at Rikers. He attempted suicide at least twice while incarcerated. Both attempts are documented in legal filings and confirmed by his family and attorneys. And here is the open loop I promised you at the start. The guards knew what was happening to him. The records show that. The evidence of his deterioration was visible in incident reports, medical logs, and complaint filings. The question isn't whether the system knew. The question is, what did it do with that knowledge? We'll get to the answer at minute 35. Kalief Browder's case was not unique. That is one of the hardest things to absorb, and one of the most important. His case was documented because a journalist found him and because he agreed to tell his story. But the conditions that created his situation were replicated across thousands of cases in New York City alone, and across hundreds of thousands of cases nationally. Let me show you 3 documented cases that ran parallel to Browder's. Cases that reveal not an anomaly, but a machinery. In another documented case, cited in civil rights litigation and reported by the Bronx Defenders, a public defense organization, a 17-year-old we'll identify as DM was arrested in 2011 on a misdemeanor assault charge. His bail was set at $1,500. His family couldn't pay it. DM spent 14 months at Rikers waiting for a trial date. During that period, according to his defense attorney's filings, he was placed in punitive segregation 3 times for a combined total of 63 days. Each time following confrontations with guards that DM's attorney characterized as retaliation for formal complaints he'd filed. His case was eventually dismissed when the complaining witness stopped cooperating with prosecutors. 14 months. Dismissed. In 2009, 1 year before Browder's arrest, the New York Civil Liberties Union documented the case of a 16-year-old from Brooklyn held at Rikers for 7 months on a robbery charge. Court filings describe how the teen, whose identity was sealed due to age, was placed in solitary confinement after a fight with another inmate in his 3rd week at the facility. According to his attorney's court filings, the teen spent 90 days in punitive segregation, officially classified as a disciplinary measure, but triggered by a fight that facility staff had documented as initiated by another party. During those 90 days, his attorney reported difficulty reaching him by phone. Visiting hours were restricted. His mental health evaluations, required by Rikers protocol, showed deteriorating psychological function. He eventually accepted a plea deal to get out. He later told his attorney he didn't commit the robbery. That is the pressure the system applies. Not through formal coercion, nothing you can point to in a statute. Through time, through isolation, through the simple, brutal arithmetic of your freedom versus your innocence. There is a legal mechanism, ancient, foundational to Western justice, designed precisely for situations like these. The writ of habeas corpus, Latin for produce the body. It is a petition demanding that the government justify its authority to hold someone in detention. In theory, it is the legal system's safety valve. In practice, for indigent defendants in New York City's jail system, it was largely inaccessible. According to records reviewed by The New Yorker and confirmed in subsequent legal reporting, Browder's legal aid attorney filed motions to dismiss his case on speedy trial grounds, a constitutional right under the Sixth Amendment. Those motions were denied. The court found that the delays, while extensive, did not formally violate speedy trial statutes because of procedural exceptions that effectively excluded large portions of the wait time. What didn't make sense was this. The Sixth Amendment guarantees the right to a speedy trial, but the legal architecture around it, exceptions, exclusions, adjournments labeled with technical designations, had hollowed that guarantee into something nearly unenforceable for defendants without private attorneys and resources to fight. CTA number 2, direct address. I'm currently tracking 3 other cases with this exact same pattern of corruption involving the Bronx DA's office and legal aid resource gaps. I'll be releasing those investigations next week. Make sure you're subscribed so you don't miss those. You won't believe how deep this goes. In 2014, after Kalief Browder's story ran in the New Yorker, attorneys and journalists made formal requests for surveillance footage from Rikers Island under New York's Freedom of Information law. What they eventually obtained, after legal battles, partial compliance, and redactions, were clips that confirmed what Browder and his attorneys had alleged for years. The footage shows several documented incidents. In one clip, a guard is recorded striking Browder while he is already restrained in a hallway. The guard's motion is visible, unprovoked by any action visible in the frame. In another clip, multiple guards are present during what an official incident report classified as a use of force event. The report's clinical language, subject was non-compliant, force was applied, does not match what the footage shows. Browder described specific incidents in interviews with the New Yorker. He described being punched by guards in corridors. He described being beaten in circumstances where he could not defend himself. He described telling guards he would file complaints. According to his account, confirmed in pattern by the DOJ investigation's findings about RNDC culture, filing complaints often preceded retaliatory placement in solitary. Dr. Terry Kupers, a forensic psychiatrist who has conducted extensive research and testimony on the psychological effects of solitary confinement in American prisons and jails, and who has consulted on federal litigation regarding solitary, has documented a consistent clinical profile in prolonged isolation cases. According to his research and testimony in multiple federal court cases, inmates held in solitary confinement for extended periods exhibit symptoms consistent with post-traumatic stress disorder, anxiety disorders, and in some cases psychosis. The isolation doesn't just cause distress. It fundamentally alters how the brain perceives safety and threat. Browder described it himself in a 2013 interview recorded after his release. He said, and this is documented in reporting, that he began talking to himself in solitary, that he lost track of days, that he became convinced at certain points that he would never leave. He said that the hardest part wasn't the violence. The hardest part was the uncertainty, not knowing if the next year would look exactly like this one, not knowing if his case would ever go to trial, not knowing if anyone outside those walls remembered he was there. Vanita Browder, Kalief's mother, visited him every chance she could. According to family accounts and interviews, she coordinated with his attorney, pushed for hearing dates, and kept contact alive across 3 years of waiting. She did not know then that she would outlive the system's release of her son by barely a year. Across nearly 3 years, Browder's case was scheduled for trial and then postponed. Again and again. Court records show at least 31 adjournments. Some delays were initiated by prosecutors. Some were initiated by defense counsel, managing an impossible caseload. Some were administrative, lost documents, missing witnesses, scheduling conflicts within an overburdened court system. According to reporting, on multiple occasions the complaining witness, Roberto Bautista, failed to appear in court. Under New York law at the time, a certain number of complaining witness no-shows could trigger dismissal. But prosecutors managed to keep the case alive through procedural maneuvering. What didn't make sense was this. Every time Browder's attorneys pushed for a trial date, the very thing the Sixth Amendment guaranteed him, the system found another reason to wait. And every day of waiting was another day at Rikers Island. In May 2013, the Bronx District Attorney's Office moved to dismiss all charges against Kalief Browder. The reason cited in court documents, the complaining witness, Roberto Bautista, had returned to Mexico and was no longer available to testify. Think carefully about what that means. The man who accused Browder of theft, the accusation that put Browder inside Rikers Island for 1,111 days, was no longer available to testify. His departure from the country was not a surprise event. Witnesses in criminal cases can be located, subpoenaed, tracked. According to Browder's attorneys, the defense had raised questions about the witnesses' availability during the preceding year. The case had been kept alive, adjournments granted, trial dates postponed, while the prosecution's sole complaining witness was, apparently, already gone. Kalief Browder walked out of Rikers Island on May 29, 2013. He was 20 years old. He had entered at 16. He had missed high school, missed the years when his peer group was forming the social and intellectual foundations of adulthood. He had survived solitary confinement, guard violence, and 2 documented suicide attempts. He was free, but free is not the same as whole. Release from Rikers Island did not come with a recovery plan. It came with a bus ticket and the clothes he wore when he was arrested. According to family members and interviews Browder gave after his release, he struggled intensely with re-entry. He described in multiple accounts that the outside world felt unsafe. Crowds were overwhelming. He was hypervigilant. He startled at sounds. He found it difficult to sleep in an open room after years of a locked cell. These are not vague or anecdotal symptoms. They are consistent with the clinical literature on post-incarceration syndrome, a term used in forensic psychiatry to describe the cluster of psychological effects caused by prolonged incarceration, particularly when that incarceration involves solitary confinement, violence, and institutional powerlessness. Despite everything, Browder attempted to rebuild. He enrolled at Bronx Community College. According to reports from professors and classmates, he worked hard. He gave interviews. He became, almost in spite of himself, a symbol. Jennifer Gonnerman's New Yorker article ran in October 2014, more than a year after his release. The response was immediate and significant. The story went national. Jay-Z read it and eventually reached out. He would later produce a documentary series about Browder's case. Mayor Bill de Blasio, then in his first year as New York City's mayor, faced direct public pressure following the publication. The NYPD and Department of Correction launched internal reviews. The story arrived at a political moment. The national conversation about criminal justice reform was accelerating, and Browder's case became one of its defining exhibits. But here's what the media cycle missed in its rush to make Browder a symbol of reform. He was still broken. The attention made it harder, not easier, to heal.